Welcome to day one of our boot camp series for 2025. It's called Introduction to Workers' Compensation. This is an overview of the Texas workers' compensation system. So we're glad you're listening in on this recording today. We're going to take you through an obstacle course of the workers' compensation system in Texas. And day one, we're going to try to take the suspense out of knowing the workers' compensation system over the suspension bridge and start your obstacle course. Our learning objectives for today are: one, know the Division of Workers' Compensation web pages that are found on the TDI website using the Workers' Compensation A through Z tool. The second learning objective is understand how the Texas workers' compensation coverage works for the employers. Remember, the employers are the insured in our system, so we want to talk about coverage. Also, to learn about some of the required forms and notices, not all, but some of the real basic ones. So that is what you will learn in the Introduction to Workers' Compensation today. Welcome to this webinar. We'll start off with a disclaimer. For every webinar that's recorded or live that you're listening to, the purpose of it is to educate system participants. It is not a substitute for the full statute and rules. Now, your Wayfinder will give you links, and you'll find it in this slide, over to the insurance code and the administrative code. To know that, it is your responsibility to know that. So if there's ever a discrepancy or a conflict with what I say and what's on the slide, the rules and the laws will prevail. So know that you have some responsibility to know where they are, but we're doing our best to teach you. The overview for today is we'll go over the regulation. When I say regulation, that means the act, which is also the law, and the administrative code, which is also known as the rules that give structure to the Texas workers' compensation system. Our goals, our legislative intent, the mission of the workers' compensation system will be reviewed here. And how does coverage work for the employers of Texas? Some required forms, providing health care to your injured employees, and the official notices that we're talking about. So this is your overview for this webinar. Talk about regulations first. What is workers' compensation? Every state in the United States has their own regulation and own rules. So if you're looking at the rules in, say, Kentucky or California, they're not the same rules that occur in Texas. So workers' compensation policies that are written for Texas employers have our set of laws and rules. So it's a state-regulated insurance program. And if an employer is covered and their employee gets injured on the job, this coverage is going to pay the medical benefits for that injury and some income replacement for the employees as they're hurt. And this is only for compensable work-related illnesses or injuries. Now, the illnesses and injuries can include psychological trauma, occupational diseases, not just physical injuries. As long as it's compensable, they can have coverage. So, what is a compensable injury? It is an injury that arises out of the course and scope of that injured employee's employment. When I say compensable, that means there's some part of it that's covered. So if you're used to, say, Medicare, Medicaid, Blue Cross Blue Shield, you would be looking for eligibility, start times and stop, and whether they have coverage or not. In the workers' compensation world, if it's compensable, that means that some part of that injury is covered by workers' compensation. So compensable means that it is a workers' compensation claim meaning injury. You'll find that definition in the Texas Labor Code 401.011 and general definitions. Now, what does course and scope mean? That means that the injured employee or the employee was performing some duty that was required for their job. That's the first prong. It was required for their job and it furthers the affairs of your business. It can happen on the premises, or say, like me, I travel some. If I'm performing duties in the course and scope and I'm in some other state, I can still have a compensable injury. So it doesn't always have to be on site. So course and scope. And it is regardless of fault. So even if your employee say they weren't exactly following your safety protocols, all they have to prove is that it happened in the course and scope of their job. Say you were at fault as an employer. There is a no fault, no blame system in workers' compensation. They can have a compensable injury if it happened in the course and scope of their job. However, there's some exceptions. Our laws and rules are written that way, where there are exceptions, and we are here to try to teach you. There are 6 exceptions to liability, even if it happened in the course and scope of their job. One is if they are intoxicated. That is written into our statute as an exception to liability for your carrier. If they were willfully attempting to injure themselves or another person is another exception, or the injury or illness was caused by a third person for a personal reason, unless it was related to their employment. Another exception is if they were participating in an optional activity. Say you had a baseball tournament on the weekend and they got hurt. That could be an exception to liability. An act of God is one of those other exceptions, or if they were engaging in horseplay on the job. That's where your carrier comes in, investigates, and sees if any of these liability exceptions exist after an injury is reported by you, the employer. Here is a picture of our regulation, and it includes 2 sets of laws. The insurance code, remember on your Wayfinder, you had links over to the insurance code and the Texas Labor Code, because the insurance code covers some parts of workers' comp and the labor code covers, it's all workers' comp. So there's 2 sets of laws. You can find them on our website at tdi.texas.gov. And on your wayfinding map, you can find links over to that, but it's easy enough to find when you go to our website. So the labor code has rules, or Texas Administrative Code, associated with the labor code. It is Title 28 of the TAC, Texas Administrative Code. Part 2 is all workers' compensation rules. Part 1 relates to the Texas Insurance Code, and it has all insurance, TDI insurance rules in there, but I've given you the 2 chapters that relate to workers' comp, Chapter 10, Chapter 19. So all of these laws and rules put together is the regulation that you need to know, and you have a responsibility to know. However, we're doing our best to train you on these statutes and administrative code. The legislature wrote the laws and the rules, and we have goals, and we have the legislative intent that we need to follow, and we have a mission in the workers' compensation system. You can see all of that information in Labor Code Section 402.021. The mission of the workers' compensation system is to return our injured employees back to their lives and productive roles in the Texas workforce. That's one of the key components of our mission. A goal is that every injured employee shall have access to the right care at the right time. So high quality medical care being offered to our injured employees, which all of us could become if something were to happen. We want to have access to high quality medical care to help them heal from their injury and get back on the job and back to their lives. So each injured employee shall receive services to facilitate that return to employment as soon as it's considered safe and appropriate. Of course, we don't want to send people back to the job if it's unsafe for them, but the doctor's going to help you decide that. So some other regulation that I wanted to talk about was the structure around how do we get injured employees back to the workplace in a safe and timely manner. We have evidence-based treatment guidelines, also known as the Official Disability Guidelines, or ODG. So we have evidence-based medicine guidelines that the doctors have access to use when they're making decisions on treatment. Everything in the treatment guidelines that's recommended is presumed to be medically necessary. Also, we have return to work guidelines. This is evidence-based medicine that tells system participants like doctors and carriers, and even employers are interested in this. It gives you information about the type of injury. If you look up the type of injury that happened to your employee and the type of job that they have, it gives you like average days away from work, minimum, maximum. So 3 points in time, benchmarks for the doctor to talk to the injured employee about, like, most people recover within this amount of time, gives and sets expectations for everybody. So we can try to prevent delayed and failed recovery for our injured employees, because we know that minor injuries sometimes can spiral out of control if not handled appropriately. So the return to work guidelines offer that for system participants. These are subscriptions that you pay for. They're available, commercially available on the market. We also have employer return to work programs. We're out there teaching employers how to develop a return to work program in their place of employment. We have a guide out on our return to work page that you can use to set up a return to work program. Also, the insurance carriers can have case managers help coordinate the care and that injured employee through the workers' compensation system. Now let's talk about Texas workers' compensation coverage. You'll find that Texas is different from the rest of all the other states in the workers' compensation system. And that is because of Labor Code 406.002, called coverage is generally elective. So if you look at all employers in the state of Texas, and I am not talking about federal employers, if you healthcare provider out there are dealing with, say, a Border Patrol agent or a post office person or an IRS person that's injured on the job, that is not any of our laws and rules. That is Department of Labor. So when we talk about all employers in Texas, it would be excluding federal employers. That doesn't, our laws and rules don't apply. So if you take all of the employers in Texas, they have a choice to have workers' compensation or not. On the left-hand side are the employers that have chosen to have coverage. So they have coverage. They're called subscribers, if you will. Sometimes they buy a commercial policy. Sometimes they're certified by the Division of Workers' Compensation to be self-insured, or they're a government type of employer. They're required. There are some employers that are required to have workers' compensation coverage, but most private employers out there in Texas have a choice. We are the only state in all of the United States that has that option in or out of the workers' compensation system. It is about a 75-25 split, basically. I think it's 76 and 24. So 75% of our employers fall on the left-hand side. They have coverage. And on the right-hand side, or about 24% of our private employers chose not to have coverage. And there's some large employers out there that don't have coverage. They're called non-subscribers. So if you're in a healthcare provider intake area, that's one of the first things you're going to try to find out. Where were they hurt? And did that employer, who's the insured, have coverage on the day of the injury? Because they could not have coverage. So you're going to find that out. Some of those non-subscribers could have accident policies, little policies, but they are not the same as workers' compensation. If you're in doubt on whether the employer had coverage, we have tools for you. There was tools on that handout. And if you're going through all of these webinar videos, you will have instructions on how to find out if your employer had coverage on the time of the injury. So let's go over the required forms. Not all forms, but the basic ones, if you're a healthcare provider out there. The first one is the work status report, DWC form 73. This form looks like this. You can find it under F for forms. If you're under the workers' comp A through Z, go to F for forms. This is what the form looks like. It is the primary communication tool between the doctor who has treated your injured employee and the employer. And it tells the carrier, the employer, and also the employee what their functional abilities are. And then the employer can make decisions about modified duty back in the workplace. So this is the primary communication tool. So the doctor will fill this out on the first visit. It is not required on every visit, but first visit. And it is what is used by the employer to make employment decisions. Also, it's a tool for the doctor to have that conversation and not just hand it to the injured employee. This should be a conversation probably on every visit on their work status. So it's submitted by the treating doctor, or if they have a properly delegated PA, physician assistant, or advanced practice registered nurse, they can complete the form also. So it's either the treating doctor, the PA, or the advanced practice registered nurse can complete the work status report. If the patient has been referred to a referral doctor, an orthopedist, that orthopedist would fill it out on the first visit. So the referral doctor will fill that out. Sometimes if there's a dispute involved, we will assign a designated doctor. Sometimes that doctor will fill out a work status report. Or if the carrier doctor, also known as the required medical exam doctor, has that as part of their to-do, they may be filling out a work status report also. Again, it's submitted on the initial examination, not in the ER, but any, say, office visit in an urgent care. A lot of our injured employees are taken care of in urgent care. On the first visit, regardless of the work status, you will be filling out a work status report and submitting it. Now, as they come in for other office visits, a work status report is not required by the rule for every visit, only when the employee experiences a change in their work status. Maybe you have them off work altogether, but you then allow them to go back on modified duty. That's a change that deserves another work status report. Or there's a substantial change in their activity restrictions. Say they're able to lift 10 pounds, but the next time they come visit, they can lift 20 pounds. That's another 73. I realize that some carriers and employers want a work status report on every single visit. It is not required by rule, and the carriers will only be required to pay you that $15 for the work status report if it's according to the rule, which is on the first visit or when there's a change, or on the schedule the carrier asks for it, not to exceed one report every 2 weeks, and it should be based on your scheduled appointments with that patient. The next form is the report of medical evaluation. This is the DWC form 69. It can only be filled out by a doctor. No physician assistant or delegated advanced practice registered nurse can complete the form 69 and conduct that exam. So this is what the form looks like here. Again, you can find it under F for forms, report of medical evaluation. The purpose of the form is to indicate whether your injured employee has reached maximum medical improvement. You'll hear us talk about MMI all the time. It's a date, and it's used to indicate whether or not you think your injured employee has the permanent impairment as a result of that compensable injury. So that's the purpose of this form. Let's just talk about MMI and what it means. It's a date, like I talked about earlier, and it's the earliest date after which you think the injured employee is not going to have any further material recovery. So they can still receive medical treatment after reaching that date. So clinically, you think they're as good as they're going to get, but they still can have maintenance or other office visits after that. So it's not an end to medical services. It's a date. Now, if they go 104 weeks from when their benefits started to accrue, that's 2 years, Then the statute kicks in and says they're at a statutory MMI. That's if the doctor hasn't put them at a clinical MMI before that. So again, it's a date. So it's somewhere between when it happened and when their benefits started to accrue, the 104 weeks. So somewhere before that or right at 104 weeks. Now there's one exception. Like I said, there's always exceptions. If the injured employee has a schedule for a spinal surgery within 12 weeks before that 104 weeks, then there could be an extension of the statutory MMI. So MMI is a date. Impairment is when the injured employee has a compensable injury and they have some loss that is going to be reasonably expected to be permanent. That's anatomical, functional loss that they've had. Say they've lost hearing, or they've lost eyesight, or they've lost use of a finger, or some other injury. So impairment is just that. And the doctor that's trained, specially trained, determines the impairment rating. Impairment rating is a percentage. So MMI is a date, impairment rating is a percentage, and that percentage is of the whole body. So they could come up with a 5% impairment rating. We use the AMA or American Medical Association Guides to Evaluation of Permanent Impairment, the 4th edition here in the Texas Workers' Compensation System. If your doctor is specially trained, they can conduct an impairment rating examination. If they are not specially trained and certified, they cannot conduct an impairment rating, and only a certified doctor can do that. MMI, a doctor can conduct an MMI exam without the certification. So only those doctors certified, and those are designated doctors, required medical exam doctors, some treating doctors. Again, I told you on the What's New slide that we're trying to increase the number of treating doctors that are certified to conduct impairment rating exams if they need to. Also, some referral doctors. So if you're referring out treating doctors not certified, but your treating doctor believes they have permanent impairment, they're going to send them to a referral doctor that's certified to conduct an impairment rating. The injured employee, does not have to have an impairment rating exam if there's no possibility of impairment. So providing healthcare to injured employees. There are 3 systems of reimbursement for injured employees that are covered by workers' compensation insurance coverage. Let's go over all 3 of them. On the left-hand side, there are public employers, intergovernmental risk pools that they join. We call them political subdivisions. They all fall under the Labor Code 504. They can be school districts, sheriff's associations, things like that. They can operate in 3 different ways, and we'll go over that in a couple slides. So we call them 504s. You can hear them referred to as political subdivisions or polysubs. Again, they're a small part of our system, but an important part that provide systems of reimbursement to those injured employees, school teachers, and sheriffs and first responders. Cities, they fall under that section. The next one are those injured employees that are receiving healthcare through a certified workers' compensation healthcare network. That's found under the insurance code 1305. We call those network claims. And then lastly, the non-network healthcare provided. The labor code outlines how they're paid, how it all works for the non-network injuries. So it's injury-based. An injury is a claim. Medical bills are separate from claim. So claim is the injury. So you'll need to find out whether a contract is involved. A contract is related to the certified workers' compensation networks in the middle. And on the left-hand side, the 504s. Sometimes they operate with contracts. So if you're looking at all the injuries, all the new injuries that are happening today, 50% of those injuries will fall under non-network, where there's no contract involved with your doctor or your hospital or your urgent care. And the other 50% generally fall under contract, which means if you're the treating doctor, you should have a contract signed or have special permission to treat those patients. So your intake and registration will be trying to find out what type of employer and what type of coverage that they have. These are the three main systems. So subject to a network. So if the injured employee's injury is subject to a network, the injury is a claim, your healthcare provider must be part of that network. It works like managed care, HMO most likely, or PPO if you want to think of it that way. Your doctor needs to have a contract with that network in order to treat and be paid for that care. Medical reimbursement is found in your contract. And say you're in urgent care, you have a contract with this network. If you're going to make a referral to an orthopedist or someone outside of your clinic, then you need to find a network provider. So they have a panel of providers that you stay within, unless you get special permission for a doctor that's outside of the network. So those must be approved in writing. So basically it works similar to an HMO. You need to stay within the network unless you get special permission to send to an out-of-network doctor. Emergency rooms, the patients can go anywhere for emergency rooms. Emergency rooms are covered, but once you get to treating doctor or otherwise scheduled procedures, then you need to be part of that network or have special permission. So that's, again, 50% of our injuries are network. There's about 26 networks, and we do have a webinar on networks in our video catalog. Those injured employees that have a claim not subject to a network, that is a non-network injury. There's no application requirement. You don't have to be contracted with us. So there's really not a contract to follow if it's a non-network injury. Medical reimbursement is determined by the medical fee guidelines, the facility fee guidelines, all of the rules on our website. So 50% of the injuries are going to fall under this. And generally, we follow Medicare payment policies if you're providing care to a non-network injury. Now, the last group that I want to talk about was the political subdivisions or polysubs. These are first responders, city of Dallas, city of wherever. They can operate in one of three ways. They can create a network, just like the certified workers' compensation networks that fall under the insurance code 1305, which means they have a panel of doctors that the patients need to choose from. Or they can operate like a non-network, which means the patient can see any doctor that they want to see, and all of our reimbursement is found in our rules. Or they can have a direct contract with certain doctors and certain hospitals in their area. Say it's a rural school district, they can have direct contracts. So your intake and registration crew needs to be finding this out. Do they have coverage? What type of coverage does this injury follow? One of these types that I've explained here. And just to note, one injured employee can have two different injuries for two different employers. So each one needs to be looked at separately to find out if it's covered by a network and contract or not. Each one of these does not have copays and deductibles for the injured employee. Most of the time, you may not bill the injured employee when you're providing treatment to your injured employees. The carriers pay the bills. So what happens when an injury occurs in the workplace? We're going to go through those notices and what happens for each participant. Notice of injury information can be found in our Texas Administrative Code and these chapters. Chapter 120 is all about what the employers have to do after an injury, what the claimants need to do in Chapter 122. And when I say claimants, those are your employees that got injured on the job, your patients, if you will. So they're claiming that an injury occurred in the course and scope of their job. They become claimants. Chapter 124 is what the insurance carriers must do during the notice of injury time period. So let's talk about the employee first, or the claimant. The employee notifies the employer after an injury or an occupational disease or any type of injury to themselves within 30 days of the date or sooner. Hopefully, you're training your employees to report that as soon as it happens. So they have to submit it to you, the employer, within 30 days of when the injury occurred, or say they have an occupational disease. There are some first responders and other people that have occupational related cancers or other diseases. Should be within 30 days once the injured employee knew or should have known that it was an occupational disease that was related to their employment. And then they also select a treating doctor at that point and informs the doctor how the injury occurred. I want to take you to the internet real quick, unless I see if I can do this. I want to show you the patient rights and responsibilities. You should be seeing the website now. This is the TDI website. This is the workers' compensation tab here. And the injured employees have a tab. The employers have a tab. And this is in Spanish for the employees, by the way. Workers' comp tab that we were talking about, and the carriers have their own. But under the injured employees tab, I wanted to point this out to everybody because the employers need to know this, the employees need to know it, and also the healthcare providers. Under the injured employees tab, there's all kinds of information for your employee, videos for them to watch, but this one right here, injured employee rights and responsibilities. Remember that last slide says they need to select their treating doctor and inform the doctor how the injury occurred. Right in here, all these are your rights and responsibilities for the injured employee. And in here, you're going to find that they have a responsibility to tell their doctor how they were injured and whether or not it's work-related. So I just wanted to point that out. It may be good for you to have that in your healthcare provider office. You can print this out, and employers, you need to know where this is, and employees do also. So let me go back to the presentation. Okay, you should see the presentation now. This is the employee's notice of injury or occupational disease form. And they are going to be filing this form to the Division of Workers' Compensation. It's the Form 41 to the Division of Workers' Compensation, hopefully earlier than 1 year after, but they have 1 year to file it to us. So under F for forms, you can find all of these forms. So this is the employee's form. They initiate this form and they send it to us, the Division of Workers' Compensation. And we also want the injured employee to keep in touch with the employer and the insurance carrier. Employers out there, please let them know, your injured employees, that the adjusters and the carrier reps may be calling them. So they expect that call and that communication. Now, what do you do as the employer? The employer files the first report of injury as soon as they find out there's an injury. They need to file it. If they're a covered subscribing employer, they need to file a first report of injury and give the employee a written copy of the rights and responsibilities that I just showed you on the website. And also, if you're an employer that provides coverage to your employees that are network, it's covered by a certified workers' compensation network, or you're one of the political subdivisions that have a network, you need to let the employee know upon hire and upon injury that, for instance, if I got hurt, we have coverage by a certified workers' compensation network as a state employee. I need to be notified that I'm part of a network, and then I need to select from these doctors, and there's a list or a link or something that I can get to the doctors within my network to choose from. If it's non-network, they can choose any doctor. So a written copy of the rights and responsibilities, and if it's part of a network, you need to let the employee know there, and you need to file the first report of injury, which is the DWC Form 001 with the insurance carrier if the employee loses more than 1 day of work. So that's a reportable injury. So don't hesitate to file there. The faster it's filed, the faster the carrier can begin their investigation into course and scope and the exceptions to the liabilities and all the things the carrier does. And most importantly, initiate benefits for your injured employee. So the insurance carrier's notice of injury should be the earliest receipt of the employer's FROI, which is the first report of injury, or they can receive notification from the Division of Workers' Compensation, or any other written communication, which could include your medical bill, regardless of source, that fairly informs the insurance carrier that they have a name of an injured employee, the name of the employer, the approximate date of injury, and information that asserts that it was a work-related injury. So if there is no first report of injury and say your bill gets to the carrier first, that initiates for notice. So the carrier, if they receive your bill, has to contact the employer regarding that injury within 7 days of that receiving that bill and work out the first report of injury there. So after the carrier receives the notice, they create a record of each reportable injury. Reportable means they've lost 1 day of work. Conducts the investigation relating to the compensability, insurance carrier's liability, like I talked about, and notifies the Division of Workers' Comp and the injured employee if there's, say, they're questioning whether there's a claim at all. Maybe it met one of those liabilities, or maybe it didn't happen in the course and scope. That's a compensability question. So that's your carrier's duty, and they have a duty to let us know with notice. So the first notice I want to talk about that's in the carrier's bucket of tools, if they question the compensability, that's the entire injury or illness or psychological trauma or whatever the claim is by the injured employee, if they deny it in its entirety, they send out a notice of denial for compensability, liability, and refusal to pay under a plain language notice 01. You can find this under F for forms, but it's at the very bottom for notices. This is what it looks like. It would be filled out, obviously, for your injured employee. The carrier is going to be filing that if they question the compensability. They are not the last say. The Division of Workers' Compensation is the last say. But if the PLN 01 is filed between the 15th and the 60th day, after they receive notice of the injury, the carrier is still liable and must pay for all medical services provided before filing that PLN 1. So you healthcare providers, especially in the urgent care area, if you get the date they filed the PLN 1, know that if your office visits are before that, the carrier could still be liable for paying, even if it ultimately ends up not being compensable. If you're treating a network claim, in the network, you get a special accommodation in the law. The PLN 1 normally just goes to the division and to the injured employee, not the healthcare provider. But in the network side, the network should be providing you notice of that PLN 1. And they may not, the carrier may not deny payment for medically necessary services up to the day they filed that PLN 1. And they're liable up to $7,000 for medically necessary care before they file that PLN 1. So the bottom line and takeaway is the carrier could end up paying some of your bills up until the day they dispute the compensability. So you'll need to know the date the PLN 1 was filed. And then maybe it's finally adjudicated as not compensable or it is compensable. Either way, the carrier could be liable up until that date. There's another type of notice that the carrier can issue. Usually the PLN 1s come at the beginning of the claim, right after the injury is reported. But there is another form called the plain language notice number 11. The carrier can file this at any time during the life of the claim. So notice of disputed issues or refusal to pay benefits is the PLN 11. This is when the insurance carrier is receiving, say, medical documentation or investigative materials, or they're looking at the diagnosis codes on your medical bills for conditions, treatments, or services that the insurance carrier believes are not related to the compensable injury. So say they accepted a shoulder injury, so there is a compensable injury, but your diagnosis codes also include a foot or another diagnosis. They could question that second diagnosis with a PLN 11. They're sending that PLN 11 to the injured employee and to the Division of Workers' Compensation. The laws and the rules don't require them to send you, the healthcare provider, a PLN 11, but you sure can ask for it from the adjuster and the insured employee. The carrier has responsibilities for timeliness of filing that PLN 11. They have to do it as soon as they're denying your medical bill for extent, relatedness, liability, and they must have a PLN 11 on file if you're receiving an EOB that says it's denied for extent. So you can ask for it if you see that they haven't filed a PLN 11 and you've received an explanation of benefits saying your medical bill is denied for extent of injury, then you can file a complaint because it should be simultaneous as soon as the carrier was supposed to pay, reduce, or deny your bill, or when you receive an EOB. So that's when they're supposed to file a PLN 11. And again, it can happen at any time during the life of the claim. Here's how you would file a complaint if you do see that they haven't filed the notices on time with the actions they take with your medical bills. You can submit a complaint to us in many different forms and formats. You can call it in, fax it in, take it to the field offices that are all over Texas, or email us at DWC complaints there. So an overview of Texas workers' compensation regulation, goals, legislative intent, workers' compensation coverage, required forms, providing health care to injured employees, and official notices. Those are the things that we have gone over today. Now we can flex your knowledge with 5 questions to see if I have transferred information over to your brain. Question number 1. To find the workers' compensation specific information on the mothership, if you will, the TDI website, a healthcare provider should use the A through Z on the workers' compensation tab, not the A through Z on the main site. The answer is yes. Use the workers' compensation A through Z. For the majority of workers' compensation information is found there. And most of you got that right. That's awesome. Number 2, which of the following is true about workers' compensation coverage? First one is workers' compensation insurance covers injuries even when the injury is the employee's fault, with some exceptions. That's 1. 2 is workers' compensation insurance covers medically necessary treatment for a compensable injury, and there are no copays and deductibles. The last one is not all Texas employers have workers' compensation coverage. All 3 of those are true. So all of the above is the correct answer. Number 3 is a work status report, the DWC Form 73. Does it need to be completed for every single office visit, no matter if there's a change in work status or activities? The answer is no. If you follow the rule 129.5, it's not required on every visit unless something's changed on every single visit. Number 4, does a doctor need to be certified to conduct an impairment rating exam? Most of you got that right, and that is yes. MMI, they don't need to be specially trained to certify MMI date, but if there's a possibility of impairment, the doctor needs to be certified. Number 5, the notice of disputed issues and refusal to pay benefits. This is the PLN 11. Can it be filed by the insurance carrier at any time during the life of the claim? And the answer is yes. As the carrier is reviewing diagnosis codes, medical records, investigative materials, they may find information where they dispute some part of the compensable injury, or the services that were provided they thought were not related, or liability exception exists. So PLN 11 can come at any time. You can always contact us with any questions at Comp Connection at 800-252-7031, option 3, or email us at any time at compconnection@tdi.texas.gov. We appreciate you attending and listening to this webinar today.